genesis of the code, go to the UCC or go to the CFR and look under administrative law. Should be under Title 18 or 28. And that'll give you where you need to go to start. The rules are there. The rules of court are there. Everything that they're supposed to do. And every courtroom I've ever been in, they've never done it. So never try and fight something on the merits. You'll never win on merits, ever. You always want to fight them on procedure. That's going to win cases for you because they're not following procedure. And you have to learn to put the right paperwork in. There's a course called Jurisdictionary everybody should look into. And I believe Mike wants to actually start a Jurisdictionary club. Is that correct, Mike?
Yes.
Okay.
I'll be speaking on that.
It's about $250 to buy it. And I took the time to transfer all the videos that you can only get online. I put them on a hard disk. So you don't have to be online if anybody's interested. You can go through a lot of that because a lot of people don't have a fast internet. We'll take care of it. Any more questions from anybody?
Yeah, Mike, can you go through the procedure, let's say for traffic court, from the filing of paperwork to talking to the prosecutor, going in before the administrator, judge, whatever you want to call them, how that typically goes in the appeals process that follows?
I can. That's pretty tall order. To start with, you are in an administrative court and you're actually in the wrong administrative court when you're in a municipal court. It really should be before a full-fledged administrative judge, not just a local judge. They don't have the authority. They say, I think it's 2B, section 2B of the Vehicle and Traffic Law gives them authority, but they don't really have it. Yeah, you can use the 11th Amendment immunity. It's the Foreign Sovereign Immunity Act would help you out. The state can't bring charges against a citizen under the 11th Amendment. It was stripped away from them in 1792. And the courts keep right on going on, even though that privilege was stripped away from them. So we really only have one Supreme Court, and there is no other court. I say we, I say under the Constitution. But if you're going to fight it out in the court, my last ticket, I threatened to do a cross-claim, and the prosecutor didn't want anything to do with that. So it's standing up for your rights. You have to object to most everything they say. And you should learn your objections. You should learn about motions. All the procedures are here. I'll give you a fast rundown of what to look forward to. I probably should have done this in. You have to excuse me, I'm a one-finger typer. That's probably why I spend so much time on the computer. Okay. I have the 1946 Administrative Act on my computer. If anybody has a flash drive or anything they want to move to, I love Skype because you can send big files over. My Skype name is Not Legal, and it's spelled K-N-O-T-L-E-G-A-L. Okay, they go by rules, and they don't have a Rule 1 here, other than you shouldn't be there. And Rule 2 covers your notices of appeal. And Rule 3 covers your docketing of appeals. Rule 4, preparation, contents, organization, forwarding, and status of the appeal file. Service of documents is Rule 5. Computation and extension of time limits is Rule 6. Motions are Rule 7. Appellants, election of procedures, which means you can pretty much pick the venue if you know how to use common law. Rule 8. That was the election of appeals. And Rule 9 is small claims. It's an expedited procedure rule. And Rule 10 is the accelerated procedure rule. Rule 11 is your submission of appeal without a hearing rule, and you certainly don't want that. You always want a hearing because it costs them money. 12 is a regular procedure rule, and that's where you normally get a Rule 12b-6, which means that you ask for something that relief can't be granted. You're there, but you didn't ask for a remedy. So they'll give you a Rule B-6 that says, you didn't ask for anything, you're just fighting. So always ask for a remedy, no matter what it is. Question? No? Okay. Always ask for a remedy when you're in court. Whether it's injunctive, which means it's not for profit, you're not doing it to make money, but you're getting them to stop something. Stop writing me tickets, stop this, stop that. That's what injunctive relief is. And that's what, I don't know if you know, private attorney generals, something created in the 60s during the Civil Rights Action. The government found that people would not fight for other people. So anybody can be a private attorney general. One of the rules is no money is involved. You cannot be reimbursed in any way, shape, or form. You have to fight them for injunctive relief only, and that is no money awards at all. So it's a great way to fight because it carries a lot more weight than saying, well, I'm going to sue you, or for my remedy, I want $1,050 gold coins, you know, an outrageous amount of money. The more outrageous it is, the less likely you're going to succeed. So if you keep it practical enough to ding them, the chances are it's going to work in your favor. Pleadings are Rule 13, and amendments of pleadings or record. So you can amend them, no matter what you submit, you can there's always a chance to amend it, especially if you request it. That's Rule 14. Pre-hearing briefs. That's Rule 15. And that's usually where the pre-hearing, they'll call it pre-hearing, that's actually your administrative work, and that's the only one you're going to get. After that, they're not going to consider it administrative. And that's how they switch hats on you. So, pre-hearing conference is 16, and Court of Appeals is Rule 17. Discovery and depositions are Rule 18. Interrogatories, departments, admission of facts, and inspection of documents. That's Rule 19. Now, one thing I found out in the case that I was in, that the interrogatories can only be sent to parties of interest. So that lets you know, I'm working on a credit card one right now for a friend, and an interrogatory can only go to persons of interest. It's a debt collection problem that I'm working on for somebody, and they're claiming that the lawyers are claiming that they're working for the bank, but they're debt collectors. So if I send an interrogatory in, the bank has to answer it. They don't answer it. In other words, the party of interest that they claim to represent are the ones that I can go after. And if they say, no, it's not going to work like that, then I know that it's just a scam, like most collection agencies have. That's for another day. That's a long-winded project right there. Trust me. Okay. 20. Time and place of hearing rule. Notice of hearing is Rule 21, and unexcused absence of a party is Rule 22. Nature of the hearing, Rule 23. Subpoenas, which you should get. Always subpoena if you can. Even if it's the person that wrote out your parking ticket, you have the right to face your accuser. And they don't like to bring him in.
I have to, having received a half a dozen because of alternate side of the street parking in the city. Having received a half a dozen tickets for alternate side of the street parking in front of the houses we have in the city of Buffalo. We finally challenged one or a house guest at our home, and we went to what's called a parking authority.
Downtown Buffalo?
Yeah, but there's one in New York City, there's one in Rochester, I think. Maybe Albany, maybe it's not Rochester.
They have to have a certain population to have their own bureau.
Yeah, there are 3 parking authorities in the state.
Yep.
We went in, and I was there to testify that his automobile was not blocking the pedestrian right-of-way. And whoever it was there that day said, well, I don't take testimony. Do you have any pictures? And I said, well, we called and we tried to secure the identity of the person who wrote the ticket. Because in Buffalo, they're not required to sign the ticket.
They give you a badge number.
They give you a number. It's not even a badge number, they say. It's just an ID number. And I said, well, then I don't get to face the accusers. And they said, no, you're right. We're not going to bring in whoever it was that wrote the ticket. And I said, well, then how do I challenge the veracity of his eyesight? If you won't let me, through discovery, to subpoena the cameras that you claim are in these vehicles, how am I going to show you that there's no evidence to support this and that my testimony, and the guy who owns the car is here to testify also, outweigh anything that you've got, because he wasn't a driver. Anyway, that bugged me. And so I talked and asked and talked and asked, and finally I found out the reason in Buffalo that they use those numbers is that they were issuing parking tickets to policemen down at the square in downtown Buffalo. And the policemen were calling them up and harassing the meter maids at 4 or 5 a.m. in the morning. I've always wanted to know, under their own rules, how legal is this? How can you even conduct an administrative hearing in a parking authority in a city the size of Buffalo and just issue ticket after ticket after ticket after ticket and not tell anybody who these people are who are writing the tickets, or allow me even to call them in so I can say, when was the last time your eyes were examined?
You can, but you can't do it on the date that they give you to show up. You can't subpoena them. The law judge can do that. And they're terrible law judges. A lot of them are bar cards, and believe it or not, they're not employees of the city. They're independent contractors.
Yeah, the authorities are independent, yeah.
Yeah. Okay, well, I've done a couple rounds downtown, and until they were all over, my research wasn't done. Now, I wanted to know where they got their authority from, and they're saying the legislature. Fine, I agree with that. And then I went a little further. It has to be given to somebody else. And here's the trick. In their rules, go to the city charter of Buffalo. Go to the common council. That's where they get their authority from. But their authority is only for commercial vehicles and public automobiles.
Taxis?
Taxis, limos, vans, all for hire. Handicap vans, your car, no. But you're there, once again, because they presume that you're in commerce. And the reason they can do that, you have a New York State registration, a New York State inspection, and a New York State plate. And your automobile is registered as a passenger vehicle.
Public automobile.
No, it's a private, you're using it in a private way. It's actually your private automobile, because you're not using it in commerce, you're not using it for hire. And that's where they got you. And I